Welcome to the New York Business Leaders Podcast, presented by the Coyle Group. We interview the most interesting and influential business leaders in New York and hear their stories of success, challenges, and lessons learned while building their businesses and personal brands. New episodes drop weekly, so please be sure to subscribe to get updates in your favorite stream. Without further delay, here's your host of the New York Business Leaders Podcast, Gordon Coyle.
Welcome back to the New York Business Leaders Podcast. I'm your host, Gordon Coyle. On today's show, Cheryl Katz Erato from the law firm Cona Elder Law joins me to talk about trust and estate litigation. So you can imagine there's some pretty interesting stories she has to tell about family disputes and how to safeguard your estate from problems down the road. We get a chance to talk about wills, trust, probate, and the types of litigation she sees in her practice. Anytime you mix money and family issues, you're bound to see disputes here and there. Cheryl's firm, Cona Elder Law, focuses exclusively on elder law, estate planning, administration, and litigation. So they've got a deep team dedicated to just this area of the law. If you'd like to connect with Cheryl, you can reach her on LinkedIn or email her at Erato, which is Cerato, at ConaLaw, ConaLaw.com, or call the firm 631-390-5000. Finally, if you have an interesting story that you'd like to tell on this podcast, why not reach out to me, Gordon Coyle. My direct dial is 845-474-2924, or you can email me at gbcoyle@thecoilegroup.com. I'll have my info and Cheryl's in the show notes as well. Now on to the show. Hey everyone, welcome back to the New York Business Leaders Podcast. I'm Gordon Coyle, and today we've got Cheryl Katz Erato with us. Cheryl, why don't you take just a minute or two and introduce yourself? Tell us what you do.
Sure. Thanks for having me, Gordon. I really appreciate it.
Yep.
So as Gordon said, my name is Cheryl Katz Erato. I am an attorney at Cona Elder Law. I'll tell you a little bit about my law firm and then specifically what I do at my law firm. So we are a boutique law firm located in Long Island, New York, and we practice on elder law, estate planning. That includes Medicaid planning, Medicaid applications, estate administration, estate litigation, special needs planning, and healthcare law. So we do a lot, but I only focus on trust and estates law, specifically trust and estates litigation, although I do some planning also.
So pretty niche.
Pretty niche, yeah.
So litigation is disputes that arise during the course of settling up an estate?
Yeah, so typically I really only get involved after somebody passes away. And the way I explain it is, it's pretty much I'm assisting my clients through the most difficult time in their life. I mean, think about it. They just lost somebody close to them. Typically it's a family member, a loved one, and they're grieving that loss. It's fresh. And then they are in a dispute about this person's assets. And typically the dispute is with family or friends or a loved one. And the last thing you were expecting is for a dispute to arise after, mom passed away. But the lesson is, what greed does sometimes is quite surprising.
So you must have some good stories.
I do. Eventually one day I may write a book. I mean, the best thing is I'm very big with New York State Bar Association. So it's a bunch of attorneys. We get together fairly often, discuss laws, discuss cases. And when you put us in a room with each other, a bunch of trust and estate litigators, they're like, let me tell you about my case. No, let me tell you about my case. We fought about a cup, a CUP cup. And I mean, the stories are endless. They really, really are. But you have to be sensitive. I mean, sometimes I listen to my client, I go, it's going to cost you $15,000 to fight over a cup. But to them, it's sentimental. I mean, they will spend whatever it takes to get what they think they deserve and what their mom or dad wanted them to get.
So what's the common timeline or storyline look like? What are the common elements, or is there common elements? Are there like the same kind of story that erupts over and over that you've seen many times in your career?
Yeah, Yes and no. I mean, there are two main storylines that I see. Typically, one of them is mom and dad. One passed away before the other. Let's say mom died first, left everything to dad. And then dad has a will, and dad has 3 kids. And then lo and behold, dad leaves everything to one of the kids because that kid was the one that took care of dad. And the other 2 kids are like, what the heck? I mean, we didn't take care of him as well as, Mikey did, but dad would never have disinherited me. So I get involved, and who do I get involved on behalf of? Anyone. I could represent Mikey, who's getting everything, or I could represent his siblings who were disinherited by dad. That's a common storyline that I see. And it doesn't have to be so egregious either, where one kid gets everything. I mean, sometimes somebody gets something, but typically, a big part of my caseload are siblings being treated unequally. Another one, believe it or not, is like aides or neighbors or family friends who come in to assist, an elderly individual, and their health is failing, and they see that their health is failing and that there are no children or other family members coming around. And those cases are quite sad. It's a lot of the times they're really taking advantage of the person about to pass away. But again, I mean, I represent the aides in some of those cases. I represent the family members that are disinherited, but those are 2 storylines that I see very often.
Yeah. I think anytime you mix money and family dynamics, you're going to see problems arise.
Yeah, and some of them are less, purposeful. I mean, a lot of cases are, somebody passes away and there's a will, and let's say the will leaves everything equally to the 3 kids, but the brother is the executor under the will. Sometimes the beneficiaries will have an issue with what the executor did. Is he stealing money? Or even less egregious than that, did he just fail to invest the property? Did he, sell property for below fair market value? So that's another thing that comes up. It doesn't necessarily have to be fighting about how the decedent wanted their estate plan to be. Sometimes it's about the management of the trust or the estate.
So maybe that's a good question to ask is what's the difference between, and how does litigation arise if somebody has a will versus a revocable trust? And how well spelled out the decedent leaves instructions. Like, I'm sure that there's varying degrees of this, but can you comment on that?
Yeah, I mean, it's a really great question. And this is why, depending on a client's proposed estate plan, it's important to have a litigator involved even before death, because a revocable trust and a will, ultimately, they do the same thing. You own your assets during life. You could do whatever the heck you want with your assets during your life. And then your revocable trust or your will says what happens to those assets upon your death. The only difference between a revocable trust and a will is the revocable trust is going to own the assets while you're alive. So, Gordon, you own a house, right? You probably own the house in your name right now. If you had a will, and there's no other joint owner or beneficiary or anything on that house, if you have a will, the will's going to say, I, Gordon, when I pass away, of course, a long, long, long time from now, I, Gordon, when I pass away, I want Cheryl to get my house. So when you pass, the will is brought to court. It's called the probate process. And the will presumably be declared valid by the judge, and then I'll get your house. Take some time. The probate process is a court proceeding. And a will is really just a piece of paper until a judge says it's valid. Now, let's say you instead don't have the house in your name. You hire a lawyer and you have a revocable trust prepared. That house will be owned by the Gordon Coyle Revocable Trust. Gordon, you'll be the trustee. You can sell the house, you can rent the house, you can live in the house, you pay the bills for the house. You do whatever you want with the house, but it's owned by the revocable trust, not you individually. So again, you pass away long, long, long time from now. That house is owned by the revocable trust. The trust will say, upon Gordon's death, I appoint so-and-so to be my trustee. That trustee immediately has the ability to do whatever you say that they should do with the house upon your death. There's no court, there's no probate. The house was already owned by the trust. So in that case, you have a trust, You say, I want Cheryl to get my house. Trustee Joe, please give Cheryl my house. You could pass away, and the next day Joe can write a deed giving you the house. That's it. No delay, no expense with the court. So why the heck would anybody do a will if you could do a revocable trust? That may be your next question. And it depends on the situation. A trust is a little more expensive now, and you need a new deed. But besides that, I advise my clients all the time, a revocable trust is probably the way to go.
So in the situation of a will, you go through probate. A probate judge says, okay, here are the papers. It all looks logical until somebody steps forward and says, wait a minute, my father really wanted this, or my mother wanted me to get that. That's when a dispute arises, right?
Correct. So probate, you're almost, when I say you're inviting litigation.
I was just going to say, it seems like that's opening the door.
Yeah, you're opening the door. That's why in, cases where, so let's say again, you're giving me your house, and your best friend, John, he's like, Gordon always said I was getting the house. You're pretty much, it's a public record, a probate proceeding. You can go online, you can see everything. And you're inviting somebody to come into court to contest the validity of the will. So it's very, very important to have a revocable trust in situations where, you're treating, let's say, 3 kids unequally, where you're leaving more to one. Because again, the will is just a piece of paper until a judge says it's valid. So when you bring the will to the courthouse, the executor will bring it in, and the executor will sign a petition saying pretty much, hey, judge, here's the will. This is when they passed away. Please declare it valid and appoint me as an executor. The judge goes, okay, but before I do that, do all the next of kin, all the family members agree with this? If they do, they typically sign what's called a waiver and a consent, saying, yeah, no, we're fine with this. But if they don't, then the judge issues what's called a citation. It's almost like a summons and complaint that you hear when lawsuits start. He'll issue or she'll issue a citation. That citation says, please be advised, so-and-so offered this will for probate. If you have any issues, please appear or have an attorney appear for you. So I get calls all the time. Hi, I got served with a citation. I don't think the will says what mom wanted it to say. What do I do? You got to appear. You have to have a lawyer appear for you. But, flip the script. You have a revocable trust. Nobody knows any of this is going on. That's it. The house is already in my name. And by the time they even figure out that the person died, I've been known in the house for a year. So it really is, you have to look at the strategy, and you have to look at the estate plan, the family tree, and how the, person who will pass away wants to leave their assets, because you really may want to do the revocable trust from the outset.
And that was going to kind of be my next question in the case of probate, there can always be somebody that steps forward and says, hold the phone. I got an issue with this. But in a revocable trust, that pretty much doesn't happen, because the roadmap's already been laid out and you're not going to a judge.
Correct. No court involvement unless, let's say, and I've had cases like this where somebody passes away and the daughter, the sole heir goes, oh, who the heck did mom leave the house to? I'm her sole heir. And then you look up online and you see that it's in a trust. She goes, mom didn't have a trust. I don't know what this is. And then you find out somebody, was unduly influencing the mother, or, it was fraud. I mean, believe it or not, people sign things fraudulently all the time. Yeah. Then you bring a proceeding. The aggrieved party brings a proceeding to the judge and says, judge, we got to, get rid of this trust. This was done improperly. And then there's a litigation surrounding that. But it's on you as the individual who is disinherited or adversely affected to bring that proceeding. Where probate, you're inviting them to have an issue. You're saying, hey, this is what happened. Do you have any issues? So it's very important to try and work around that if at all possible.
Do you have any guidelines or best practices for families? Like, is there if your estate is valued at X, you must have a trust? Or like, in your mind, should everybody have a trust, or just above a certain wealth level? How does that work?
So, I mean, kind of above, a taxable estate, you definitely want to have, different types of trust to do tax planning. And I have, my estate planning department that would handle all of that. But, for the most part, you almost don't want either. I mean, if you have a typical family, mom, dad, and a few kids, typically you want to have your kids listed as joint owners or beneficiaries of your assets. So things can pass without a hitch once you pass away. I'm a big advocate for trusts, whenever they can be used appropriately, just because it prevents any kind of court process, which, isn't great for my practice. I'm a litigator. So it's putting best practices put me out of practice, but there's more than enough work to go around, so it's okay. So when I do planning, I do it from a litigator standpoint where I want to try and prevent litigation. Some clients are very, very uncomfortable about trust. It doesn't matter how much they learn about it. They feel that I just want to own my house my way and I don't want to change it. And in those cases, if they're treating children unequally, or they're doing something where litigation may arise in the future, what I typically do, best practice, is I start my litigation file now. I take copious notes. I write exactly when I met with the person who eventually will pass away, what they said, why they said that, who else was in the room. I make sure nobody else is in the room, who hired me, who paid my bills, who contacted me. So at least I have my entire outline of what I would say if I was deposed in the future as to why my client did what he or she did with his or her estate plan. So that's, as a litigator, that's probably, what I focus on, best practices.
My dad passed away about 6 or 7 months ago, and thank you. One of the things that we talked about was how well planned out everything was, and health proxy, and he had been sick for a period of time. Health proxies, final wishes, trusts. So we just kind of, my brother and sister and I, we kind of felt very lucky that we were in a position to execute what he wanted, even though he was incapable of his final wishes and how he wanted to go. And then how the remnants of his estate were to be, distributed. And that plan gave us such enormous peace of mind, like, oh, we weren't screwing up. This is what dad wanted, So I'll give advice and just kind of say from my own personal experience that having it all laid out in a very well-written document with, all the legal stuff that needed to be taken care of, and the appointment of the trustees and the process, it was just a very smooth, confident feeling going into the end of his life, and still kind of unraveling all of the assets and distributing and investing them. We just kind of feel like we're in a really good place because we're all on the same page, because we knew this is what he wanted. So for anybody that hasn't gone through the process, I think it's an important thing to do. And, I think a lot of people, they wait until they're in their late 60s, 70s, 80s, like, what are you waiting for?
Exactly. What I say to clients, if you're over the age of 18, you should have exactly what you said, the advanced directives, the healthcare proxy, the power of attorney, because once you're an adult, you really need to appoint somebody to assist you in case you can't do it yourself. So it's very smart your dad had that, because let's say, for example, he didn't have a healthcare proxy or a power of attorney. There's nobody who legally can speak on his behalf. And in those cases, what happens is you actually have to bring a proceeding, another court proceeding, this one in the Supreme Court, for a guardian. And then the guardian makes, financial decisions, for example. Because nobody has the right to sign something for an adult who can't sign something himself without a document in place. So it sounds like your dad got good legal advice. So I'm happy for you and your family, because it's hard. You're grieving your father's loss, and he just passed a few months ago. The last thing you want is now to fight with your mother or your siblings. Oh no, dad didn't want this, dad wanted that. It's all laid out. There's no questions, there's no disputes. And that estate planning attorney, put me out of a case, which is good. Which is good. That's the goal. I don't want to be involved in your family drama, Gordon. So I'm happy to hear that.
We're a no drama family.
Yeah. And it's when you said before, you're like, this is what Dad wanted. It was clear what Dad wanted. What I find interesting in trust and estates practice is there's something called, it sounds kind of blunt. It's called the dead man statute. And if you as an individual have a beneficial interest in the estate, so let's say you're going to get money, you're not allowed to testify at trial as to what the decedent wanted. So it's barred. So, if your dad said to you, Gordon, I want to give you all of my money, and then there's a will that says I'm leaving everything to, Cheryl, if we went to trial, you are completely barred from saying, no, Dad told me he wanted me to get everything. It's called the dead man statute. But now if a neighbor was present for that conversation, the neighbor could testify as to what Dad said. But it's funny when you say, this is what Dad wanted, because some cases it's not so clear. And the one person who really thinks they knew what Dad wanted can't even tell the court or the jury what the individual actually wanted.
Interesting. Is that because they just think that anything that person would say would be so, they could lie so blatantly that
the decedent can't, rise from the grave and say, that's not what happened.
Yeah.
It's inadmissible. Inadmissible hearsay.
Yeah. Interesting. How do you get clients? I mean, there's disputes that take place every day over these kinds of things. How do they find you? Who recommends you? Things like that.
Yeah. So it's interesting. I mean, a lot of my practice is word of mouth. I mean, I was just at a Labor Day party, last week, and I'm sitting around a table with some new people I never met before. And, it's sad, but when I hear somebody say, oh yeah, my grandpa passed away, I'm like, oh really? Where did they live when they passed? And the individual's, grandfather had just passed away. He was a Queens County resident, and I practice, in Queens very often. And I go, oh, did he have a will? Like, what's the administration, looking like? I'm a trust and estates lawyer. Believe it or not, they're in the middle of this huge dispute, and he was going to look for a lawyer. So
no kidding.
I got a client from a Labor Day party.
You just never know.
You never know. And it's like, you talk to everybody, and I'm all about educating the public and giving advice wherever I can. So I love doing it. I'm a trust and estates nerd, and I love talking about it. So if I can ever help anybody, I'm always available to help. Typically, interestingly, most of my practice comes from trust and estates lawyers, because they do the planning, they can write the will, they can write the trust. But then once things start getting a little funky, they call me up. They're like, Cheryl, things are getting weird. My client died. The son keeps calling me. He showed up to my office. He's fighting everything. That's when I'll get involved at that point. It also is interesting because a trust and estates planner can only be involved to a certain point, and then they're conflicted out. I mean, they're going to be a witness at trial. They're going to be deposed. So they'll call me and say, I have, a deposition coming up. Can you represent me? So that's where most of my business comes from. Financial advisors also, real estate brokers. It really, you can't get away from death and taxes, they always say, right? So.
Interesting.
Yeah.
So before we hopped on the call, I had looked on LinkedIn, and I saw that you were awarded a who's who for 2022 in professional services. Tell us about that award.
Yeah, so it's Long Island Business News. So it was in the newspaper. It was very exciting, and I was able to write an educational article, as who's who women in professional services. So what I chose to write about was estate planning in light of the COVID-19 pandemic. And I was very involved in, assisting other attorneys through the pandemic, because the governor issued emergency executive orders, which allowed estate planning documents to be done remotely, virtually, which had never been done before in New York State. A lot of states actually do allow it, but New York State never has allowed it. And we actually have a very strict execution ceremonies. So it was interesting to, be involved in that aspect of it. But now, as COVID-19 patients, pass away after signing their wills, there's a bunch of case law out there about what needs to be shown to a judge for a COVID-19 will to be probated. So it was a great honor. What I liked about it was it gave me an opportunity to educate other practitioners and the public about what's happening currently in trust and estate law.
Interesting. That's great. Congratulations.
Thank you.
And I think that, for any professional, I do a lot of it myself. It's educational based because it builds your credibility and it gives you an opportunity to speak to people that maybe you would not have a connection with otherwise. And then, other professionals see you in a, oh, I can rely on Cheryl. When I have a question, she'll know the answer. And because she's an educator and willing to share her knowledge, I'm sure she wouldn't mind answering a question.
Exactly.
I think that's a big piece of our marketing. And I think a lot of people that we know are probably in the same boat, that this kind of like idea of professional education, putting yourself out there, like this podcast, just talking about what you do. You just never know what positive impact it could have on somebody. It could spark them to say, I have a question on trust and estates, or I'm a beneficiary and I'm getting a hinky feeling that my trustee or somebody is not treating me properly. And they just didn't know that there were avenues to follow for that.
Yeah, I just had a case on my desk last week. The mother died 7.5 years ago, and my client as a beneficiary hasn't gotten a penny. He had no idea there was anything he could do. I'm like, 7.5 years. So I'm working with him now, to try and get him what he's entitled to, but it's about being educated. I mean, you just don't know. Now, I'm very lucky. I've never had a dispute in my family about anybody's estate. So I wouldn't have known, at that time what my rights were if a dispute had arose. So it's very important to get, the information out there.
Mm-hmm. And somebody that, like your client that hasn't seen a penny in 7.5 years, what happens if the estate has been squandered by another party? Like, what repercussions does he have? What can he do? You can litigate.
Yeah, I mean, you bring a proceeding against the fiduciary. First, you bring an accounting proceeding to say, well, you've been a fiduciary, an executor, a trustee, an administrator. That's a fiduciary. You've been a fiduciary for, in this case, egregious 7.5 years. Typically, it's not that long. Typically, it's a year, 2 years. What have you been doing? Like, I haven't gotten anything. What on earth have you been doing? So you bring that proceeding to the judge. Almost always the judge will say, okay, you have the ability to bring this proceeding as long as you have what's called standing. And the judge, again, you get that citation, back to the citation, get the citation, you serve it on the fiduciary. And then they have an ability to say, well, I don't need to account for this and this reason. Typically, they're going to have to account for their actions. They put in a judicial accounting explaining everything that they've done. And then your client, the beneficiary, has the ability to question them, request bank statements, records, examine them, look at what they've been spending on legal fees, taxes, etc. And then, if there are grounds, you file objections and you start a suit for the most part. The trustee, the executor, they could be sanctioned. They could be responsible for all legal fees. They may have to pay interest. Some courts will put the fiduciary in prison if they fail to account in a timely manner. So one of the courthouses in Long Island, the surrogate there put in an elderly woman in jail for failing to file an accounting in a timely manner. It's no joke. It's no joke to be appointed the fiduciary of an estate. So.
Why don't you define what a fiduciary is?
So it pretty much is just a fancy term for an executor, a trustee, or an administrator. It's the person that's in control of the assets, however the assets are. So a trustee is the fiduciary of a trust. The executor is the fiduciary of an estate. So that means the executor was nominated under the will. And then an administrator means somebody died with no trust or no will. The court will appoint the administrator based on New York state law. So if, let's say, you have a spouse, the spouse will be the administrator under New York state law unless they can't do it for some reason. And it's statutory what allows you to be an administrator. But will allows you to contract around that pretty much, and that's an executor. But all three pretty much do the same thing. You owe, as a fiduciary, the utmost loyalty and respect to these beneficiaries. Your entire job is to collect the estate or the trust assets, put them all together, invest them appropriately, and then distribute them pursuant to the terms of either the will, the trust, or New York state intestacy law. But your job as a fiduciary is to take care of those beneficiaries.
But the interests of the beneficiary is well ahead of yours.
Well ahead.
And from the beginning of the conversation, when you mix money and relationships, sometimes you end up with not such great results.
Yeah, I mean, I just had a case. The financial advisor, he was involved with investments, and he helped the decedent with their investments during their life. She appointed him as the executor. And after she died, he continued to help with the investments. But what he was doing was he was investing in certain securities where he was getting kickbacks. And the securities weren't doing great. So the beneficiaries, what would have been in $1 million estate, when the beneficiaries were getting their distributions, the executor goes, oh, the investments didn't do so well. You're only getting, $10,000 each. You're like, what? This was $1 million estate. Where did all the money go?
Yeah.
So what do? You bring an accounting proceeding. You look at everything. And that's when we saw that the advisor was getting kickbacks and investing in certain securities where he was making a percentage, and he didn't care how the investments were doing. He wasn't a beneficiary. And he gets a commission also. So the fiduciary gets paid. You get paid for a job. So he was getting his commissions, all his legal fees were covered, and he's getting a percentage on his investments. So the case settled, gave substantial money back to the beneficiaries. But it's crazy, the stories. It's crazy what you can actually say.
Yeah, that's a shame, because at the end of the day, the financial advisor puts his license at risk. He may be out of a career. He's going to get beat up in court. He's going to pay the money back. He's probably going to pay some kinds of penalties and fines as well. It just doesn't end well. If you're a fiduciary, do your job.
Yeah, and that's why these things settle. I mean, once you really figure out when somebody did the wrong thing, it's pretty much, I'm like a detective in the beginning, where I'm serving demands for discovery, I'm taking depositions, I'm examining, interested parties, disinterested parties, serving subpoenas, I'm investigating, I'm trying to figure out what happened here. And then once I have enough, then I start making the phone calls to the other attorney. Counsel, what on earth did your client do here? Are you really sure you want to litigate this? I think it's time you call your client and we get this resolved. Typically, the case is settled. It's very, very rare for surrogates court or trust and estate matters to go to trial. It happens, but it's rare. These things settle.
So you must have to deploy forensic accounting folks to look at records and things like that. You don't do that internally.
No, I don't do that internally. It depends on how active the banking is and how substantial the assets are. But on large estates, 100% we need a forensic accountant.
What about, are private investigators hired to kind of dig through stuff? So
yeah, sometimes.
So you're like
very crazy cases.
You're in the middle of this interesting.
Oh, it's amazing. This is why I love talking about what I do. I don't work a day in my life. It is so interesting.
Yeah. I feel the same way. I don't get involved in things like what you do, but I have the same interest level that it's just like every day is a new day. Every day is a new problem to unravel. And when you do the right job for a customer or client, they just feel like, wow, this person really knows your stuff. That's great.
Yeah, the thank you cards that I've gotten, some of them bring tears to my eyes. They really do, where it's a kid that never had anything, was taken advantage of by somebody else, and then they actually got what they deserved at the end of the day. So
Nice.
it's rewarding.
Yeah. Cheryl, we're coming up on about 40 minutes of our conversation. I want to be respectful of our time. Is there anything else that you wanted to go through, talk about? Anything we missed?
No, I think that's a great general overview as to what I do.
Okay.
I could talk about this stuff for another 5 hours. So.
And I could on insurance as well, but nobody wants to hear it.
Exactly.
So if somebody wanted to reach out and speak to you about a particular case or just find out more about you and your firm, how's the best way to go about doing that?
Yep. So the firm is Cona Elder Law, and Cona is Cona, and you can just Google it. But the phone number is 631-390-5000. And then my email address is C for Cheryl, Erato, ERATO, at Cona, CONA, law.com. So Erato at ConaLaw.com.
Great.
Shoot me an email. I admittedly answer pretty much immediately, unless I'm in court or a deposition, including on the weekend. So shoot me an email if you want to talk to me. I'm happy to talk.
Cool. I will put that contact info in the show notes and in the description box as well. So if somebody's unable to jot it down right now, they can do that at their pleasure. Cheryl, it's been a great conversation. I appreciate you being on the show. Thanks.
Thanks so much for having me. Had a great time.
You're welcome. And if you have an interesting story you'd like to tell on this podcast, give me a call, drop me an email. I'll put my contact info in the show notes as well. And until next time, stay well. Thanks.
That's it for this week's episode of the New York Business Leaders Podcast. Be sure to subscribe so you don't miss next week's episode. In the meantime, find more interviews and resources at nybusinessleaders.com.